Hi, everyone. Thank you for joining us today for our webinar, Graduation Now What? We're going to be discussing what estate planning documents your 18-year-old needs to have. Today, we're going to be hosted on behalf of Merhab Robinson and Clarkson. These are a few of our practice areas. We specialize in business and estate planning. Today, you're going to be presented to by Paula Clarkson and Cassidy Russell. And after we go through some of our slides, we'll have an opportunity for a Q&A. These, Paula and Cassidy are two of our associate attorneys here. Paula is a founding partner, and we should be all good to go. I kindly ask that you please submit all of your questions in the Q&A feature, and if you have anything technical, you can feel free to put them in the chat. It looks like most everybody's logged on, so we can go ahead and get started.
Okay, so let's talk a little bit about what you can do when you turn 18. There's lots of positive things besides graduation, including the ability to get married, sign a contract, buy your own car, manage money, and sign legal documents like doing a will or voting, and consenting to your own medical treatment. So those are a few of the positive things that your now grown-up adult child can do. Now, there's also the question of what could go wrong with all of those things. You can get married without the consent of a parent. We can always make a bad choice when we do that, but at 18, we might be a little more prone to a bad decision. You can sue someone, or you can also get sued. You also are welcomed into medical privacy rights. You have the ability to keep your medical information private from your parents. And you can manage property without supervision, meaning you can spend your whole bank account if you want to. And you can join the military without parental consent. That could be good or could be very traumatic for the parent involved.
I'm going to give you a hypothetical. I'm Paula Clarkson. Let's say that you have your child, they're going off with some friends to Texas for spring break. They're driving across the country with some friends. They get in a car accident. You get a call from one of the friends that your child's been taken by ambulance to the hospital in Texas, but they're shaken up. You don't know where your child is. You don't know how to find them. And you start panicking and start calling hospitals around Texas, which can take up a lot of territory. So the reality of the situation is, even if you get a hold of the hospitals, they are not legally allowed to release medical information, because if your child is 18 years or older, they have protected private medical information. They may not even say if your child is even being treated at the hospital. So calling around could just cause more frustration. You won't even know where to go. We've actually had a very similar situation. My business partner, her son was in the hospital and he was over 18 and he was unconscious for a little bit, and the hospital right here in Orange County would not speak to her because he was an adult and had protected medical information. So there's ways that we can get around this and let you continue to help your young adults become mature adults and make right decisions and be able to access their medical information and financial information. So the first is we recommend that you set up a foundational plan. We call it a foundational plan because it's the basics of any 18-year-old should have: a healthcare directive, a HIPAA authorization, and a power of attorney. Now in California, unless you have assets that exceed $184,500, you don't need a will or a trust. The assets by law would go to your the child's parents. So in many cases, the graduating high school seniors, the college age kids don't have assets that are that high. So that's why we call it foundational. It doesn't include the will and the trust for people that do have assets exceeding that $184,500 limit. So the first document is the Advanced Healthcare Directive. So the Advanced Healthcare Directive allows the child to say, these are the people that can make my medical decisions. Everyone that we've done, all the children always name their parents, thankfully. But the children technically could name anybody that they want. So, but it says here who is legally authorized to make my medical decisions for me. If I can't, we can specify, pain relief at all times. Do the end of life decisions such as life support? How long do they want to be kept alive, depending on the situation? Do they want to donate organs or body parts or not? Do they want to keep them? Some people are very, very specific about their choices. So this is a great way to have the kids start becoming an adult and making those decisions for themselves, as well as if they have plans for if they prefer to be buried, cremated, basically disposing of their remains, should the worst happen. But this allows you to do that so that if you were calling around to the hospitals, having the healthcare directive says, no, look at, I do have legal authority to make the decisions and talk to you. The second document that goes along with the healthcare directive is called a HIPAA release. And that's based on Health Insurance Portability and Accountability Act. And as Cassidy mentioned, when all of us turn 18, we have protected medical information that the doctors aren't allowed to release our medical information to just anybody that comes in, whether that person is a parent, a sibling, even a spouse. The hospitals can be sued, or medical providers can be sued for releasing that information. So having the healthcare directive along with the HIPAA says, healthcare providers, insurance agents, whoever it is, can release my protected medical information to the people that I have named in the HIPAA release. Now you might think, well, I pay for my child's medical insurance. They're on my insurance plan. I pay the bills. Why shouldn't I be able to talk to the doctors? But that's not the law. We have paying for it and having access to it are two completely separate things. So it's also helpful, we're talking about the worst case scenario if there's an accident or something happens to your child, but it could be something as simple as calling and making sure that the medical bills are correct, that they're being charged appropriately when they're getting dental work, or they go and see the doctor, that the insurance is being applied correctly. They're not going to talk to you without having the HIPAA release and authorization. Now, if your kids are already at 18, 19, early college age, you may also be aware that there are some rights in California that go into effect for children when they turn about 14, that the doctors are not allowed to release certain information to the parents regarding, pregnancy, treatment for it, contraception, sexual assault, sexually transmitted diseases, and different things like that, for the protection of the minor. Now, the minor can waive it at that point, but they are in a weird area because the minors have this protection, but they don't have the ability to create a healthcare directive and a HIPAA. So in those cases, it's more of a verbal consent when you take your child to the doctor before they're 18 years old. But when they're 18, we do want them to actually execute the healthcare directive, the HIPAA release. And as I mentioned, the HIPAA is more for who can access the medical information, what doctors are they able to communicate with, so that the information can be released. Oftentimes we'll have people that will name, maybe their parent, but they allow their sibling to also be on the HIPAA, or they may allow somebody else that they trust, or if we're talking about an age that usually is not married, but if the child is married, they're in their early 20s, the HIPAA, they may name their parent on the HIPAA, but name their spouse as the healthcare decision maker. So the healthcare directive decision maker is different from HIPAA. HIPAA can be more expanded, saying all of these people can get my medical information and talk to my doctors. However, the healthcare directive is these are the people that actually make my medical decisions. Oftentimes they are exactly the same people, maybe in different orders, parents first, siblings second on the healthcare. The HIPAA is just everybody that they authorize your release of medical information to.
Okay, so now we're going to kind of jump over to the financial side of things, because your 18-year-old is then in charge of their own money, which is good, bad, or indifferent. I didn't have a lot at 18 to manage anyway, but I definitely know that there were some things that I was probably irresponsible with, including maybe spending a little too much money. Fair enough. But we recommend doing a durable power of attorney, which allows your child to name who would access their financials, including doing taxes and paying bills and all of those things on behalf of them, should they not be able to. Very commonly, I recommend that this actually be effective immediately, because at 18, I don't know about you, I wouldn't have wanted to call Social Security or the IRS or something like that and have to deal with my own taxes if I was having issues. So those are things that generally the 18-year-olds will grant to their parents on an immediate basis rather than waiting for incapacity. But a durable power of attorney would handle any assets that are outside of a trust. So in their individual name, held in joint tenancy with someone else, paying taxes, dealing with Social Security, Medi-Cal or Medicare, and safe deposit boxes, which maybe are a little more antiquated for time being, but those are all things that they would be able to access with a durable power of attorney. And in some ways, you would think, okay, what about finances related to paying for their tuition at school? Might not be covered by this document. And that's why I want to talk to you guys about what FERPA is. FERPA is the Family Educational Rights and Privacy Act. It's federal law, and it was designed to protect the privacy of students when they get to post-secondary institutions, so college. Regardless of their age, if they're in college, they have privacy rights related to their educational information. That could be their financial aid information, their grades, their disciplinary conduct, whether they're going to class, all of those different things. Private protected information for a student. So your 17-year-old that you're paying tuition for thousands and thousands of dollars doesn't have to tell you anything about their grades, and neither does the university. So one of the things that maybe we don't draft, but your college would draft, they generally speaking have a FERPA release. So when you go to open house or new admitted students night, you can find someone from the registrar usually, and they will have a FERPA release that you can fill out, which would then allow your student to say, my mom and dad can call and ask about my grades and my financials and check in on my financial aid. And you might want to make an agreement with your student that we'll continue to pay and you'll continue to share your grades with us. That might be a good trade-off at that point. Okay. All right, so let's talk a little bit about how we develop a foundational plan. A foundational plan isn't always just for our 18-year-olds, but can also be for an adult that maybe doesn't have a lot of assets. As Paula said earlier, that the trigger for probate is $184,500. And so what does that process look like? I like for the 18-year-olds to have the experience, the grown-up experience of talking with a lawyer, coming in to sign, different things like that. Generally speaking, a lot of them want their parents to come along, but if you want to usher them into adulthood, you can say, you make the appointments, you make it happen, and happy to meet with them. Usually it's about a 30-minute conversation about what the documents do, who they would want to appoint, and how the procedure works for us getting everything done. We have a worksheet that will just tell us a little bit about them and who they want to name, probably phone numbers as well to include on those different documents. We talk about their wishes related to their finances and their health. And then we send out draft documents for them to review. I encourage them to read them all the way through. Maybe they won't understand every word, but that's okay. That way we can talk about what they like, what they don't like, questions, all of that good stuff. And then we can have them come into our office. I think it's a great experience for an 18-year-old to come into a law office where they have to meet with the receptionist and say, I'm here to visit this person and sign my documents today. They bring their ID in and we get them notarized. But if it's more convenient for you or we're a little far away, you can sign them at your convenience, meaning you could go into your local bank, or FedEx and UPS stores have notaries as well to get those documents signed. And we would just ask for a copy. And then we recommend you provide documents to their doctor to show who is on their healthcare directive and their HIPAA release. And then you can also provide it to financial institutions if you need it to be able to help them financially.
We promise that we aren't scary with the kids. It's always a great opportunity for them to actually have a first experience, kind of moving into adulthood, and show them that, you know, things actually matter at this point. You know, if they're sued, you know, they can be sued. They are adults now. We're playing in the big times now. Things don't just get pushed under the table or anything like that. And, you know, we always explain to them that, you know, they do have the attorney-client privilege and they don't have to bring in their parents. But also too, God forbid they were in a, you know, having some trouble, or mostly, hopefully, you know, it's not them and it's a friend or something. They know that they have someone that they can call, and that we have to keep it private. But we can direct them, you know, to someone that perhaps could help, you know, if it was a criminal matter or something like that. Since we don't do that, but just getting them into realizing that, you know, things can happen. Unfortunately, we've had a few clients where the situation has arisen with their kids that are in college, and it's a lot better to know that they have the documents in place to have the authority to do what they need to do. So, as we mentioned, it covers finances, you know, their assets, ability to access, your ability to access assets for them. So if your child is in the hospital, is in a, God forbid, in a coma, or has some other ailment, that having the power of attorney would allow you to be able to contact all of the financial resources that might be necessary. Without it, then you would be in a position that they would not speak with you, and that you may have to file for a conservator of the person. If your child was in that big of an injury or having issues, that it was going to last for a significant period of time. On the flip side as well, there's called a there's two different parts: conservator of the person, ability to make their medical decisions; conservator of the estate, of being able to make their financial decisions. So having both the healthcare directive and the HIPAA and the power of attorney will avoid having to bring the court in, because the children have already named, or young adults have already named, people to make their medical decisions and family decisions for them without having to involve the court. So I know that this was a lot of information in a quick point of time, but if you have any questions, we're happy to answer them.
Yes, thank you so much to Paula and Cassidy for the wonderful presentation. At this time, we're going to open up the session to any questions. As I mentioned before, please submit your questions and answers in the Q&A feature. If you have, again, any technical problems, you can feel free to put that in the chat. That also goes directly to me. But if not, we'll go ahead and dive into the questions. So I received one question. It says, should my children remain on my car insurance when they turn 18?
You can keep them on your car insurance, but we do recommend that you put the car in their name, because that is a liability. If they get in an accident, they could potentially be sued. So the question is, if they were to get sued and there was a judgment, let's say for $100,000, if the car is owned by you, then most likely you are going to be named in the insurance or the lawsuit, because you're the one with the money, your child does not. So by putting the car in their name, they can be sued all they want. If they don't have any assets, it's not that big of a deal, because the issue with the kids is that the parents are often, you know, you should have known that they were going to do this. You should have known that they drive recklessly, or you should have known they were going out to a bar and were going to have a drink, and you negligently allowed them to use your car. By putting the car in the child's name, you've now eliminated your portion of the liability. And depending on your insurance company, they may allow you to keep the same policy, but or they may require you to have a separate policy. But definitely the owner of the car, keeping in the kids' names, eliminates any liability that would go over to the parents for any negligence that the child has committed, or even just accident. You know, it happens to us all.
Thank you, Paula. Another question we got was, can my child change their healthcare directive when they get married?
Yeah. So once your child is 18, they have the ability to dictate who is their agent. So right now, generally most 18-year-olds, honestly, all the way up until they probably do get married, would name their parents. And then we always recommend revisiting these types of documents when major life events happen. Birth, marriage, death, divorce, all of those different kinds of things can be a reason to look at your estate planning documents, including who is named on your healthcare directive and your power of attorney and your HIPAA. Might want to still leave your parents on your HIPAA so they could call and ask the doctor, how are you doing if you're in the hospital and things like that. But maybe your spouse would be the one that you would want making end of life decisions. So yes, always time to revisit and re-execute documents at that point or update them at least.
This also reminds me that if your children do any semesters abroad or summers abroad, to check with the program, because the California Healthcare Directive and HIPAA power of attorney may not be valid in another country. So making sure that if they are in another country, that there are documents in place for them during that period of time to see if, just in case there was an accident or something happened.
Thank you. Another question that we got was, how do these documents relate to the privacy that kids have when they turn 14?
That's what I mentioned before was these documents are for when anybody turns 18 years old. So you have to be careful. There are some minor confidentiality rules in California. I know that when my daughter turned 14, then she had to start authorizing me to be able to come into appointments with her because the state wants to protect these teens if they do have questions on, like I mentioned, the biggest issues are pregnancy, contraception, abortion, sexual assault issues, sexually transmitted diseases, and things like that, that they can receive and consent to treatment, but the parents are not able to get access to that information without the child's consent. So it's a weird area of about 4 years until the children can actually sign off and consent in writing that their parents can access anything with the healthcare directive and the HIPAA versus just verbally authorizing it. So it seems a little contradictory because they're given the ability for the private information before they're 18, but they don't really have the ability to execute estate planning documents or enter into contracts and things like that. So it's just a separate little law that California allows. And I would assume that many other states do. It's more of a public policy type of thing.
Your health insurance may have a specific form that they'll let your child sign. I don't necessarily agree with the ability for them to contract into that either, but if the health insurance has a form for them to sign, maybe that's something you could look into as well. So.
Perfect. We got another question. Writing as a grandparent, what are health insurance options for a child of age 18 who is not being supported by either parent?
So my initial thought, because I've been in that situation when I was in college, I know Covered California is kind of our insurance marketplace in California that you can look into if they're wanting to do it on their own. And there are sliding scales based on their income or assets, depending on if they're just a student. They also can be seen at usually their health center through their university or community college as well. But I'm not sure how your specific health insurance would cover a dependent that's a generation removed. You can always call and ask them as well. But Covered California would be my first stop for anything like that. Paula, do you have any thoughts too?
Yeah, I would check with your health insurance. If the grandparent is wanting to put the grandchild on their health insurance, if the child is fully dependent on you and you're taking them as a dependent on your tax return, that check with your health insurance company and see if they're allowed. Otherwise, as Cassidy mentioned, Covered California, as well as a lot of universities have programs that will cover the students as well.
Great. And then we did get one other question saying, how can I motivate my 18-year-old to get these documents in place?
We laugh because sometimes the parents are like, just come on down, we have an appointment. um,
Yeah.
Usually all the kids that we've talked to they understand. We explain the importance of them. Usually like Cassidy mentioned, we can either do a call, a Zoom, have them come in person. We explain the need for it, and they understand it. We try to get it done. We understand, they may go away to school, so we try to do it over the summer, or if they come home for Thanksgiving or the holiday break and stuff like that. But most of the time the kids they're pretty amenable to it. Just explain, or sometimes just bring them. We'll talk.
Yeah, I would say the motivation in this situation is probably a little less subtle, a little more, we're going to go talk to this person. And that's generally how it happens.
Yeah, but like we have never had any problems with the kids. Most of them are understanding, and I think the biggest thing that we've ever had is sometimes the 18-year-olds don't have a driver's license or ID. So that's always an important thing, because the documents need to be notarized. So I know a lot of kids are choosing not to get driver's license as quickly as perhaps we did before. But if they have, a state of ID, or they even have a passport, then the documents can be notarized and executed.
I will add, you can always give us a call. We can send you the worksheet, have your son or daughter go through it and fill it out. Then maybe that'll motivate them to actually do it.
Yeah. It's a good time to start talking to them about your plan as well, so that they know what to expect in the future. I know nobody likes to talk about death or illness, but it is a reality of life. And, the more prepared we are, the better it is for everyone.
Agreed. Well, it looks like that's it for our question and answers. Thank you so much to our presenters, Paula and Cassidy. As I mentioned before, our firm hosted this, Merhab Robinson and Clarkson. We do business in estate planning. If you need any help, you can always give us a call here. This is our email as well. If you missed our Estate Planning 101 webinar, it is linked in our website and on YouTube. So when you're there, you can also check out our additional resources. We have lots of really great blogs with a lot of information on there, and videos that you can also check out. We are going to be hosting another webinar on June 19th, where we're going to be discussing special needs trusts for anyone who might have special requirements. So follow us on our socials, and you know where to find us if you need us. Thank you so much for joining us. Have a wonderful day.
Thank you.